Good afternoon. Good afternoon to everyone who has joined us this afternoon. We are happy to have you. This is the first FKE members webinar in the year 2023. We are privileged to have a very intensive discussion that will start in a few minutes. And before we start that conversation, I would like to just give us some few guidelines for our session today. We are discussing the Nssf Act 45 of 2013. And to guide us, if you have any question or comment, you're requested to post that in the Q&A panel. In the Q&A panel, that way then we'll be able to pick it up and address it with the panelists. If you'd like to address your question to any specific person within the panel, please do indicate that as you post your question, and we will be able to direct it to the right person. We may not have adequate time to allow live conversations, and therefore that's the reason I would like you to post that. We hope you take note of that in good time. Without wasting much time, we'd like to go straight into our conversation for the day. And at this point, I would like to invite our CEO and Executive Director, Madam Jacqueline Mugo. Mrs. Mugo is our captain here. She has a lot of experience in the field of employment and labor relations. She has worked with the Federation for a long time, and I believe you have all interacted with her in one way or the other, and you found her inputs useful in steering the issues of employers in this country. Madam Mugo is the Secretary General of Business Africa as well. She's a titular board member of the ILO and the Vice President for Africa in the International Organization for Employers, IOE. She was the first chairperson of the East African Employers Organization, and therefore you can see the scope of experience that she has. Madam Mugo is a lawyer and has practiced in this country for a long time. Her contribution towards policy formulation has led to the adoption of various progressive practices by employers in this country, particularly in the areas of social protection. And that informs some of the conversations we are having today, knowing that we have an expert right here in the room and as a captain. So with that, I welcome you all. And at this point, I just would like to hand you over to our CEO who will guide us in the next conversation. Madam Mugo, karibu sana.
Thank you very much, Grace, for your warm welcome and the introductory remarks. It is my pleasure to host you all to this first webinar that the Federation of Kenya Employers is holding this year. It is our intention to have regular interactions with you, our members, and other friends and stakeholders. Today, we thought it was important for us to bring employers together to discuss a very important development, the Nssf Act 2013. And we wanted to do this alongside organizations and institutions that really understand different aspects of it and can bring into the conversation areas that employers have been asking us about in the last few weeks. And we thought you should hear from RBA itself and also from a qualified actuary who's been working in this area for a long time. So it is my pleasure to introduce to you those who will be with me on this panel as we seek to bring more clarity into the Nssf Act 2013. We are facing a change, huge change with this Act 2013. So the speakers that we have and who I'm pleased to introduce to you this afternoon, the first one is a person I've known for a very long time, Mr. Sandeep Raichura. He is the CEO of the Zamara Group Limited and also chairman of the Kenya Pension Fund Investment Consortium. Ever since I met Sandeep, he's just been talking about pensions. And I know he's been very involved in the crafting of the Nssf Act that we currently have. He is an actuary by profession. He has over 30 years experience in this field. He's handled matters actuarial, pensions, and investment consultancy, both here and also in the UK. He's been at the forefront of the pension debate in this country, and as he'll be sharing with you as we continue, you'll see that actually he was right at the heart of cooking this new act, if I may call it that we're discussing. And he has, over the last 2.5 decades, really entrenched himself in this field. He's been involved in and contributed to all aspects of the pension conversation in Africa. He's provided thought leadership, pensions, reform, and also regulatory issues, looking specifically at social security. I know he's also been involved in that, in the area of product innovation and investment. So a very warm welcome to you, Sandeep Raichura, and we look forward to having this conversation with you this afternoon. The other panelist we have is Mr. John Woolley, who is an actuary in the Supervision Directorate at the RBA. John is a senior supervisor at the RBA. He also advises the government on technical pension matters at the National Treasury. John has a wealth of experience in the pension space, which spans over 8 years. And he is a fellow of the Institute of Actuaries, UK, and a member of the Pensions Working Party of the Actuarial Society of Kenya. In short, John knows his stuff. So these are the two people that will be joining me from an FKE perspective to discuss this issue. I want to give you some background as to how we come to be where we are today. And I need to disclose that I personally have also been quite involved in the conversations leading to the Nssf Act 2013. I have served on the Nssf board for many years and only retired last year. So the Nssf Act 2013 was actually a creation of Nssf. We agreed to it, but some of the areas that we wanted clarified and some of the protection measures that we wanted included in it perhaps were not well managed. So there's a long history behind this act. It ran into headwinds when it was suddenly declared to be in force in the year 2013. That took us by surprise. It had been assented to in December around the Christmas season. And suddenly we found ourselves facing the implementation of an act when we were really still looking forward to having a conversation around many aspects, which I'll be highlighting. So let me say on behalf of the Federation of Kenya Employers that we do support the issue of adequacy of pensions. It's very important that at the end of a long working life, someone retires on a pension that can support them in old age when they need it most. And it is true that the level of contributions we make to the Nssf is insufficient, and that the pensions that people get, in fact, it's a one-off payment. It's not even a pension scheme at present. So the Nssf board, after a long time of consideration, did agree to this act. But we knew that we needed to clarify what it would be implemented on and also the quantum. So when the act was suddenly assented to and declared to be in force in 2013, unfortunately, it ended up in court. We all know what the first decision was, and we find ourselves here today because of the most recent decision of the appeal court. So the process leading to the envisaged increase and improvement in retirement benefits for employees has unfortunately run into headwinds. The recent Court of Appeal judgment, I will not focus discussion on the details of the merits and demerits of it, but as employers, we honestly feel that the issues that we raised in the initial stages, when we went to court, or employers went to court in the year 2014, have still not been addressed. It is important to have these issues addressed. Many members have asked us whether the FKE is now happy with the act, because we issued an advisory, I think it was last week, when the court decision came out. It is important that we say that when decisions are made by the courts or laws are passed, as long as that is what pertains as the law, the Federation then advises members to comply with it. And that is the position we find ourselves in. The Nssf Act was brought back into force by the decision of the Court of Appeal, which was recently issued. And that advisory sought to answer very many questions that employers were asking, what do we do now? Do we obey this act? Yes, as long as that is what still pertains. So that advisory still holds, it seeks to clarify. And some of those aspects is what we'll be discussing today. What does it mean? What is the level of deduction we have to make? What do we remit to Nssf? What do we remit if we have a private pension scheme? And these are questions that both Sandeep and John will help us to unpack. One of the key issues that we had and still have is how do we deal with gratuity as employers? Because we have employers who have gratuity schemes, and we think that it would be a duplication to maintain these gratuity schemes, especially at a time when we've enhanced the contributions towards Nssf and also other pension schemes, or on the whole, we've increased pension because we had wanted these to be clarified, and that's why the first court case was asking the court to consider how to treat pension, how to treat gratuity, and we wanted a situation where any deductions that employers were making towards gratuity could be then remitted to whichever scheme the employer would now move to when these enhanced contributions came into force. That issue has still not been addressed. How do we deal with gratuity? Traditionally, we know as employers that statutory deductions are effected on the basic wage, whether you earn consolidated salary or a basic wage and a separate element of housing. That basic wage is where the deduction is implemented or effected. We have this idea of the definition and what the Act talks about pensionable earnings, and that is an area also that we had hoped the court would address itself to. I know that Sandeep will explain that we have the upper earning limit and the lower earning limit, which sets the levels of deductions at this stage. But still, the pensionable earnings element, there's still a bit of unclarity as to whether these pensionable earnings, because we know the lower earning limit and the upper earning limit will actually be reviewed annually based on what the Act says now. So that's an area that we really needed to look at. This may have been overtaken by events for now, but we had also wanted the implementation date to be a date that is discussed and agreed by the parties, to give time for employers on the market to be ready, so that when implementation comes, at the point when we'd have been ready, then everybody would have been on board. So this is an important conversation for us to have as employers. And we want to kick off really by me giving a chance first to Sandeep to help us understand, and we will be going back and forth on some of these issues. Sandeep, I know, as I've said in the introduction, that you have a long history with this Act, and that you really have been at the heart of crafting it and also advising the Nssf as a fund. You know, as employers, what to grapple with ultimately is the cost of labor. The cost of labor in this country is high. And when the increases that happen suddenly, that has an impact where employers are not given time to prepare. So part of the questions that many members have been asking us is, okay, so what exactly has changed? Would you highlight the key changes that are presented in the Nssf Act number 5 of 2013, just in about 5 minutes. And then I will also ask you to clarify for us or to share with us what you think the impact of these changes are to private insurance schemes in this country, because I know this is a sector where you work. So 2 very important questions for you, Sandeep. If you could do this in about 7 minutes, it would be good. So over to you, Sandeep.
Okay, thank you very much, Jacqueline. And first of all, let me say how very honored and delighted I am to have been asked to participate and be a panelist and help to unpack the act and respond to any questions.
Sorry, Sandeep, there's a bit of an echo. I don't know what's happening.
Are you able to hear me now? Is there still an echo?
We can hear, I can still hear my voice. I don't know.
Maybe she can mute. Jacqueline, have you muted yourself? Maybe that might help if you mute.
We're good now. Sorry, please proceed. Okay. You know how technology is.
I know. So I hope everybody can hear me well. And it's really good to see more than 800 people on this webinar, which just goes to show the level of interest in this subject. And naturally, Jacqueline, when you have a new piece of legislation like this, there will be concern, there will be anxiety, apprehension, and suspicion. And I hope that I can address a lot of the questions that people have, and also, the rationale for some of those changes. So if I look at the act, there's a lot of detail in it. But if you ask me for, highlight a few things, and let me just pick on about 4 or 5. So the first and foremost important change, ladies and gentlemen, is that this act, yes, it does increase the level of contributions that are mandatory, whether it is to the Nssf or whether it is to a private pension plan. But in essence, the main purpose of this act is to make savings for pensions compulsory. Okay, so every Kenyan who is in working employment is earning a salary. The act requires the individual to be registered and make a contribution. And those contributions are now based on a percentage of earnings or salary. Previously, as you will all know, we were contributing 200 shillings ourselves, and our employers were matching that with another 200. So we were having a total of 400 shillings a month going to the Nssf. What a lot of us don't appreciate, that even in the previous Nssf Act, contributions were actually at 10% of pay. It is just that there was a ceiling on those contributions. And that ceiling has not been adjusted, or has only been adjusted twice in the last 57 years. Okay, so what this new act does is it expresses the contributions as a percentage of salary. So it's 6% by employees, 6% by employers. There is still a ceiling on the earnings which are pensionable, and that is at 4 times national average earnings, which is over 200,000 shillings now. Okay, and these contributions, the intention is that they will be phased in over a period of 5 years so that employers can manage their costs, and employees can also, in terms of the pinch on take-home pay, will be spread over a period of hopefully 5 years. So for the viewers, the listeners, the most important change is the increase in the level of contributions expressed as a percentage of earnings. And Jacqueline will come on to discuss the issue of what earnings definition that is in a few minutes, if we may. Okay. The second thing is that together with the change in the contributions, there is a corresponding increase in both the range and the level of benefits that are provided. So there is a wider range of benefits that is provided by the new Nssf. It is expected that given the higher level of contributions, the benefits will be that much higher. And also, it's important to appreciate that these benefits, whereas the previous Nssf used to give us the benefits in the form of a lump sum. So when somebody retired or exited or died, all they got was a one-off lump sum payment, which was very, very low for starters, but also paid out as a bullet point cash payment. Under the new Nssf, the bulk of the benefit is taken as a regular pension. Okay, so when somebody retires, there will be a regular amount that will be paid. Only a small portion, up to a third, can be taken as cash. Also, future contributions will have to be preserved until retirement age. Okay, so statutory contributions cannot be accessed when people change jobs, as has been the case previously. Okay, the other very important change, and this is important for all those employers who operate their own schemes or are worried about what they will contribute to the Nssf, is that the Act allows that employers can opt out of making the second level of contributions, what is called Tier 2. From the Nssf, they can put it to their own scheme if they have one, or if they don't have one, they can establish one or participate in an existing umbrella fund. So there is the facility to opt out, which is very important. And finally, this new act also brings in a lot of measures to strengthen the corporate governance of the NSSF. So there are quite a number of checks and balances that have been introduced, a lot of safeguards to wrongdoing that have been introduced. For example, the Act very explicitly provides that the NSSF will be subject to the regulatory oversight of the RBA. It will need to comply with investment guidelines. The assets are invested by external investment managers held by external licensed custodians. Many of you may not be aware, but over 80% of the assets of the NSSF are not held by NSSF. They're actually held by external managers and custodians who are licensed by the Retirement Benefits Authority and the CMA. Also, there is a cap on the expenses that NSSF can have. So that cap is in place, and it will be carefully monitored. There are requirements on disclosures, benefit statements, annual general meetings, publication of financial statements. So a lot of checks and balances have been brought in. Okay, so those were the key highlights of the Act. And now let me turn to the second part of Jacqueline's question, which is, what impact is this expected to have on private pensions or the private insurance industry? And contrary to what a lot of people feel, actually, this Act will be highly beneficial to the private pensions industry. Not only will the pensions industry remain relevant, but it will actually flourish. Because let's look at it this way. Currently, Jacqueline, the number of employers, and Jacqueline, you would tell me how many employers we have in Kenya, but the number is more than 80,000. Maybe not all of them are members of FKE, but that's the number of registered employers in the country. The number who offer retirement benefits to their staff is just over 3,000. So there's a huge gap in the number of employers who offer retirement benefits to their staff. If I look at the people employed in the informal sector employment in the country, it's just over 3.1. The number of people who are actually contributing to a pension is just around 1 million. So there's close to 2 million people whose only source of retirement benefit is the NSSF. And so what the point I'm trying to make, Jacqueline, in response to your question, is that the size of the market is 3 times bigger than it is in terms of the size of the workforce, and almost 40 times bigger in terms of the number of employers. Okay, so to the extent that employers choose to opt out of second-tier contributions to the NSSF, yes, they will. The private pensions industry will significantly flourish. Okay, I hope, Jacqueline, that addresses both the questions that you had for me. So those people who feel that, and those people who are saying that this is the end or the death knell for private pensions in Kenya, I think it's not correct. Actually, the contrary is going to be true.
Thank you very much, Sandeep. You've done very well and really managed your time in a commendable way. You've raised some fairly significant points there, talking to us about the impact and the level of increase of contributions. And you've talked about the ceiling in the savings and really the spirit of savings behind this. And even hope that this is actually a good move. I think those present will discuss that. And also talked about the tier 2 opt-out option for employers. One of the issues that keeps coming up is the issue about corporate governance and whether the funds are safe. I'm sure those listening will want to ask questions about that to be able to fully understand and to know what's in place. And also the issue about the impact of the increases on the private pension schemes in this country, which has been a key concern to us. And that really leads us very well to John. And one of the issues employers have been grappling with is RBA ready to give us this opt-out arrangement? Because I think it's important that they be given that comfort. So John, could you share with us the arrangement that RBA has put in place to support the implementation of this act and the changes that are envisaged? This idea of opting out of tier 2, what is the process? And what are employers supposed to do so that they're not frustrated when they try to be exempted, I think that's the word, from having to remit tier 2 contributions. So if you share this with us, then it would give us some insights.
Thank you. Thank you very much, Madam CEO, and the entire FKE team, together with your membership, for inviting ourselves, RBA, as the industry regulator, to share a few insights on this subject matter, which I completely agree that it's a topical issue. I'm honored to have been sent to represent the CEO of RBA, who was not able to join you today. So as a start point, I think going straight to your question, I just want to confirm that RBA is very ready for this change. And I would support that by the following. And I'll just start by where Sandeep ended in terms of the contribution rates. So Sandeep alluded to increase in contribution rates, which are increasing from what we have been used to, 200 shillings by the member and 200 shillings by the employer, which essentially are increasing to 12% of the member's salary. Now, for majority of the employers or employees, this translates to an absolute figure of about 2,160 shillings. And for some employees, it is actually lower. So it is important to make that observation that for some employees, it will be lower than that. Now, these contributions are expected to keep increasing. They actually graduated from year 1 all the way to year 5. So they will keep on increasing. Will not forever be contributing 2160. And that figure is likely to keep on going up. The contributions have been split into tier 1 and tier 2. Tier 1 is essentially around 360 shillings. Out of this 2,160 shillings by the employee and another 360 by the employer. There is a tier 2, which is significantly higher, which is about 720 by the employee and 720 by the employer. As I said, this is for majority of the employees, but not to everyone. A significant number of members have been affected by these changes. And some of these members of other private schemes, as Sandeep alluded. Now, the law, the Nssf Act that we are discussing today, allows employers who have other private pension arrangements to opt out and make the tier 2 contributions to their private pension arrangements. So this is a contribution of roughly, again, going back to my example, of about 1,440 shillings. So out of the 2160, 720 is expected to go to Nssf, that is tier 1. And there is a tier 2, which is around 1,440, which the law has permitted employers to contract out from Nssf to their private pension schemes. So that process, and I believe it's a key area of discussion today, we are calling that process the contracting out process. Now, such schemes and employers who have private arrangements are expected to apply to the regulator to be approved so that they are able to contract out. The process of approval, it's something that I'm going to discuss in the next few minutes. But it's important to observe that both the schemes and the employers are expected to apply separately because they are issued with different approvals by the regulator. So as a regulator, we have two roles, essentially, in this discussion. The first role is who we have always been, and that is being a regulator, being a supervisor, monitoring and supervising both the private pension schemes and the Nssf itself. The second role, which I believe is more important today, is the role of approval contracting out process by the employers and pension schemes. So how prepared are we? So we started by issuing a communication back around a week ago, around 14th of February, 2023, which we published in the newspapers just trying to tell employers, yes, there is an option for you to contract out and what that process would entail. So the authority is also in the process of issuing guidelines to the industry so that we can actually give you a step-by-step process of how you are going to contract out of Nssf, if at all you wish to. It's actually not mandatory for employers to contract out, but we have seen a lot of requests, a lot of interest for employers who want to contract out of the Nssf. So we are working on a guideline. These guidelines entails the documentation that is required from these employers and the timelines for contracting out. A very pertinent discussion at the moment, considering that most of the employers are currently working on their payroll, and some have even closed their payroll. So it's an issue of time. How fast can this be done? We are also actively sensitizing schemes, members, and other stakeholders, including service providers, on these changes so that we can try and create as much knowledge as we can so that everyone is at par in terms of knowing what the process entails. We have already received some applications from certain employers and pension schemes, and I just want to confirm that as an authority, we have a team in place, our technical team is in place and ready to process those applications. We are further engaging or planning to engage the Nssf itself so that we can firm up on some of the areas where we have seen that we need to discuss in terms of giving a way forward on implementation of the Act. So yes, again, I just wish to confirm that RBA is ready. We have a team that is ready in place just to process those applications. But in the meantime, we are going to issue guidelines to the industry that will guide employers and pension schemes in terms of the contracting out process. Just as I conclude, I just wanted to look at some of the documentation that we foresee would be expected from employers. So we have an application form, which we are calling Form C1. This is a form that we expect employers to fill in and submit to the regulator. This form has certain information that we think it's critical in terms of compliance to the Act. We also require the employers to make a resolution. So if an employer has a board of directors, we need them to make a resolution, just telling us that indeed the employer has agreed to opt out. An undertaking as well by the employers to contribute as per the Nssf Act, and that is with regards to the new contribution rates. We also required resolutions from the Board of Trustees of these schemes, agreeing that they're actually okay with accepting those contributions with regards to Tier 1, which I said that can be contracted out. So trustees as well need to sit and make a resolution that they do agree to accept those contributions and manage them based on the fiduciary role that they have in these pension schemes. Schemes are serviced by fund administrators. We also require a commitment from the fund administrator that they agree to comply with the provisions of the Nssf Act with regards to Tier 2 contributions. Employers are also expected to notify the affected members in terms of giving them a notice on the effect on their contributions and their benefits and their salaries. As a regulator, we also expect to receive a copy of those or that notice that is served to the members. And once we receive this documentation, the authority is then expected to issue what we are calling a contracting out certificate to the employers. For the schemes, remember I said the processes are 2 in 1. So the schemes as well are expected to apply to the regulator. We are also expected to conduct a check on the scheme and confirm that indeed it fulfills the requirements of the Nssf Act with regards to Tier 2 contributions. One of those requirements is an amendment to the trust deed and rules of the scheme, just accommodating the Tier 2 contributions from Nssf. I'm glad to confirm that majority of the schemes have actually done that. In the first instance, when the Nssf Act came into place in the year 2013-2014, some employers actually were proactive and were able to amend their trust deed and rules to accommodate the tier 2 contributions. So we do have schemes that are in that regard are already compliant, but there's also a significant number that is not compliant. So in case a scheme is not compliant, we expect a copy of that document. And then secondly, and lastly, very important document is what we are calling the reference scheme test certificate. Now, this is a certificate for defined contribution schemes prepared by your administrator, just confirming that they have done all the checks that are required, and indeed the scheme is ready to accept and manage tier 2 contributions. For defined benefit schemes, because of their complexity, require this certificate from an actuary who looks at the benefit structure of the scheme just to confirm that indeed what members are receiving from the scheme is superior to what the Nssf Act is promising. And these requirements have actually been provided in the 4th schedule, but they will also be part of the guideline that we are going to issue to the industry, guiding the administrators and the actuaries which areas they're expected to look at. And then once we receive those 2 documentation, the authority will issue what we are calling a reference scheme certificate. So the output is 2 certificates, a contracting out certificate for the employer and a reference scheme certificate for the scheme. Madam CEO, I hope with that I've been able to respond to the query. Otherwise, I'll be happy to shed more light on it as we progress. Thank you.
Yes, thank you very much, John, for your very exhaustive response and sharing with us the arrangements you put in place as RBA to facilitate employers to opt out. And I must say, I've been quite impressed by the turnaround time of RBA, and you're preparing to support this process, because we know, the court decision came out on a Friday, and by the following Friday, the Nssf had said the act should start being implemented. So I just want to have a follow-up question, because I know the different documents and the processes you've talked about perhaps would be what is in the guidelines. Are all these available on your website? Can employers do all this process online? And specifically, how long do you envisage this process would take for an employer to get the contracting out certificate and also the reference scheme? Because as you're aware, as matters stand now, although I know there's indication that people are going to court, but if matters stand as they are now, and employers are required to meet this or to get the opt-out from the RBA in time for the next statutory contributions, which is due by the 9th of next month, and knowing the number of schemes we're talking about, and the documents are quite a number, understandably so. Will employers be able to get this opt-out in good time for them to be able to comply next month, in your view?
Thank you very much, Madam CEO. That's a very relevant question in terms of the timelines that we are looking at. And I'll just start with what is known as per the law. So the law, the Nssf Act that we are discussing has provided a timeline for contracting out. So it has said that employers, once we receive an application at the regulator's level, the employer can only contract out after 60 days after that application. So if we receive an application today is on 20th of February, then the earliest that the employer can contract is maybe for the April salaries, which are expected towards the end of April. So within a period of 60 days, that is the earliest that the employer can contract out. So we are already looking at a period of 2 months that contributions will most likely go to Nssf, even for tier 2, for majority of the employers, actually, I believe for almost all the employers. And then after the next 2 months, then that is when the effect of the contracting out certificate will kick in. How long do we have to issue the contracting out certificates? Again, the law has given us 30 days to process contracting out certificates. So once we receive an application today, within the next 30 days, we should have issued a contracting out certificate to the employer, provided that they have fulfilled the requirements that I stated. The same applies to the reference scheme certificate, which is being issued to pension schemes. So the regulator has 30 days to issue these certificates. However, the contracting period, which we can call the notice period, still stands at 2 months. So you apply today and you still have 2 months for you to be able to effect the contracting out process from the scheme.
Thank you. I'm sure the audience will ask some questions about that. Let me go back to Sandeep and asking one question before I come back to you, John, and then we'll open up the floor for discussion. I'm sure there are lots of questions being posted. But Sandeep, back to you, and I'd like you to help employers understand the implications of the changes of the Nssf Act to the payroll. If you could demonstrate this, what does Tier 1, Tier 2 deductions mean? What then would be the net result? And how could you help employers best understand the subsequent transitions and provisions that there are?
Okay, Jacqueline, you've known me for 20 years, as you said earlier. And one thing you know is that I'm maybe very good at the actuarial stuff, but not at the little maths. So for that, I've got my colleague Adil, who will very ably take us through a few illustrations to help us understand this Tier 1, Tier 2 very clearly, and how much goes to your own scheme and how much to Nssf and the transition. Over to you, Adil.
Thank you, Sandeep. So thank you, Jacqueline, and good afternoon, everyone.
Good afternoon.
I'll just share my screen to illustrate, to go through a couple of illustrations. Can you confirm, Jacqueline, that you can see what I'm presenting?
Very clearly, very clearly. You can proceed.
Wonderful. So I think John talked on this a little bit as well, mentioning that there's a couple of things I remember him saying a few minutes ago that I wanted to sort of reiterate, which is the contribution of which you've seen a lot of, which is 1080, is based on the upper earnings limit of 18,000. If somebody earns less than that, they're not necessarily going to contribute that much. So I wanted to reiterate that, and also reiterate what he said about the upper earnings limit, that it's going to be changing quite dramatically. And so the contributions that you're seeing for year 1 are not going to be around very long. They're going to go up. So just to recap how the new Nssf contributions work. So effectively, each party, so the employer and the employee, each party is required to contribute 6% of pensionable earnings, okay? So that's a total of 12% if we add up both parties' contribution. So the pensionable earnings is your gross consolidated salary for all intents and purposes, subject to a ceiling, okay? The ceiling is called the upper earnings limit. So what that means is that you will contribute 6% of your salary on earnings up to the upper earnings limit. If you make a salary above the upper earnings limit, that additional salary above that figure would not be subject to Nssf contributions. So I've got 3 examples I'd like to walk the audience through. The first one is an illustration for somebody whose salary is 10,000 shillings per month. And before anyone tells me the minimum wage is higher than this, it's just for illustration. It could be a part-time worker, it could be a casual employee, etc. Okay, and so the first thing we need to do is calculate pensionable earnings. Now, in year 1, if my salary is 10,000 and the upper earnings limit is 18,000, then my pensionable earnings is 10,000, the lower of the two, right? The last column on this slide, I'll try and just put a laser pointer on it for a second. So this column here, so the column in the middle shows you what will happen in year 1. So effectively, what's going to happen this year. This column here is to try and show you what things will look like if there was no transition. So remember, there's a 5-year transition period, and over that time, the upper earnings limit will be changing dramatically. So I wanted to give you a sense of what will happen if there was no transition, to give you a sense of what the future looks like. Okay, so this column here is with an upper earnings limit of 160,000, because after the transition period ends, the upper earnings limit is defined as 4 times average earnings, and average earnings are around 40,000. So 4 times 40,000 is 160. Okay, the first example is relatively straightforward. We've got earnings of 10,000. Since the upper earnings limit is higher than that, our pensionable earnings is simply 10,000, and our contribution is 6% of 10,000, which is 600. Okay, and you can see that this member is contributing 600 today, and if there was no transition, they would also be contributing 600 because their entire salary is already pensionable under the Act. Okay. Now, the second part of the table over here, we show you how to split up the pensionable earnings. So the pensionable earnings of 10,000 would become 6,000 tier 1 earnings and 4,000 tier 2 earnings in year 1. Okay, and that's because tier 1 is your contribution on your pensionable earnings up to the lower earnings limit, which is 6,000 under the transition rules. Okay, so if we have a low earnings limit of 6,000, then our first 6,000 is tier 1, and the remainder of our salary, which is 4,000, is tier 2. We can then take 6% of each to calculate the two tiers. So tier 1 contribution is 6% of 6,000. Tier 2 is 6% of 4,000, which is 360 and 240. And look at that, it adds up to 600. So in terms of your question about the impact to the employer, for an employee who's earning 10,000 shillings, the contribution is going up. Sorry, just move the slide 1 second. Let me get back. The contribution is going up from 200 to 600. Okay, so the employee will have to contribute an additional 400, and the employer will have to contribute an additional 400 for this example. If I now move to the next example, in this example, I have an employee earning 100,000. Okay, and this is where you'll see the impact of the transition. Okay, you saw on the first slide, the contribution was 600 for that member, regardless of where we are in time. For this member earning 100,000, it looks very different. In year 1, we have a salary of 100,000. The upper earnings limit, remember, is 18,000. Therefore, our pensionable earnings is 18,000. It's your salary up to the earnings limit. Okay, so in this case, 18,000. The total contribution is simply 6% of that, which is 1,080. Okay, and that's a number you guys will have seen in the newspaper and different adverts. If we split up the 18,000 into the tier 1 and tier 2 earnings, tier 1 earnings are earnings up to the low earnings limit of 6,000. So in this case, that is 6,000. And then the tier 2 is the earnings above 6,000. So 18,000 minus 6,000 is 12,000. So that's how we get this split. And then we can calculate 6% of each. So tier 1 contribution is 6% of 6,000, 360. Tier 2 contribution is 6% of 12,000, which is 720. And if you add that up again, you get back to that total contribution, which I already calculated, of 1080. So in this example, somebody earning 100,000, in year 1, your contribution is going from 200 to 1080. So it's an increase of 880 shillings. And that's 880 shilling increase for the employee and the employer. Now look what happens where we move out of the transition period, for example. If I'm earning 100,000, and the upper earnings limit is 160,000, which is the direction we're going in, then my pensionable earnings is the entire 100,000 because my full salary falls under the upper earnings limit. So if there was no transition, this member would be contributing 6,000, not 1080, which is only for year 1. Okay, so this member is going to increase contributions from 1080 to 6,000 over the next 5 years, and even more, to be honest, because obviously salary would change and things like that. So if we now split the 100,000 pensionable earnings into tier 1 and tier 2, without transition, the lower earnings limit is effectively minimum wage, which is around 15,000. So we would say tier 1 earnings is the first 15,000. Tier 2 earnings is the balance, which is 100,000 minus 15,000, which is 85,000. Okay. And then we can calculate the two tiers of contribution. 6% of 15,000 is 900. 6% of 85,000 is 5,100. And again, if we add that up, you're getting back to the 6,000 total contribution. So look at how big the impact becomes over time. From contributing 200, we'll be contributing 6,000. Okay, so that's an increase of 5,800 for the employee and 5,800 for the employer. So thankfully, there's a 5-year transition. So we will get there over time. But it's really important to understand what the future will also look like. We shouldn't just focus on year 1. And in the last example, I take a higher earner, somebody earning 300,000. And what you'll see in this example is they will they will hit the upper earnings limit even in the future, and therefore their full salary will never become pensionable. Okay, so in the first example, the first year looks the same as the guy of 100,000 because both people are earning over 18,000. So I hope that's clear. So in this case, the pensionable earnings is 18,000, total contribution of 1080, and then the split is the same. Okay, but if we assume no transition, the salary is going to be 300,000. The upper earnings limit is 160,000. That means this person's pensionable earnings is 160,000. Okay, it's not the full salary, and 6% of 160,000 is 9,600. Again, we split it up into tier 1 and tier 2. Tier 1 earnings is 15,000 out of the 160. Tier 2 is the balance of 145,000. Okay, 6% of 15,000 is your tier 1 contribution, 900. Tier 2 contribution, 6% of 145,000, which is 8,700. And so this member, somebody earning as high as 300,000, would be contributing 9,600 in the long term to the NSSF. Okay, so compared to 200, that's a jump of 9,400 for the employee and 9,400 for the employer. So that is really a summary of the impact on payroll in terms of the additional cost to the employer. So I'll give it back to Sandeep there, and hopefully that provides the clarity you needed.
Thanks, Adil. So I hope Jacqueline, Adil has done justice and explained this well.
Yes, he has. Thank you. We have figures. Our minds are racing. Just thinking about those figures and looking at the 9,600. But I'll leave it to the audience to respond. Thank you very much, Adil. And thank you, Sandeep, as well. Let me now, John, ask you the final question before we go to receive questions from the audience. And that's if you could highlight for us what the post-retirement process of accessing the money saved under NSSF and other occupational schemes is under this new arrangement, or will be under this new arrangement.
Once again, thank you. Thank you very much. So the process after the member exits employment, and let's remember, a member can exit employment through various ways. You can resign, you can choose to take early retirement, you can fall sick, unfortunately, or you can even resign on normal grounds. So I'll start with retirement on normal grounds. So in case you are a member who is with an employer who doesn't have a private pension arrangement, it means that your full contributions, both tier 1 and tier 2 of what Adil was presenting, will go to NSSF. So NSSF will invest your money, and when you retire, your account will have a balance. So that balance, you will approach NSSF for payment. Now the law provides for a board of payment of those benefits, which I'm going to highlight shortly. The other thing that I want to point out is that for majority of us who have been transitioned to the new NSSF Act, we were also members of the former Act. And therefore there was a scheme which Madam CEO started by alluding, that was a provident scheme that was paying everything all at once. So for those benefits that we had saved prior to February 2023, the benefit will still be there. The scheme will continue to invest, that is NSSF. And therefore, when you retire, don't forget that you'll have two funds. You'll have what you had already saved up to 2023. And then there will be what you'll start saving from February 2023, which will be in the new scheme. Now, the former scheme will pay you everything all at once as they used to, or as NSSF used to, which is in form of a lump sum. But the new scheme will pay you your benefits in two forms. One form will be in form of what we call a pension, which is ideally a series of monthly income for life. And that will be about 2/3 of your benefits will be utilized to pay you that income. A third of your benefits will be paid as a pension. And that is a key difference between a pension scheme and a provident fund. The new scheme is a pension scheme. The former scheme was a provident fund. Therefore, as a member, you'll be entitled to a lump sum from the former scheme, which will continue to be a provident fund. And you'll be entitled to another lump sum from the new scheme up to a tune of 1/3. And 2/3 will be payable to you in form of a lifetime income every month. So that is one of the key differences that as members we need to realize that the new Nssf is bringing in. And Sandeep did allude to that. So let's go to the second category of members. So what happens to me if I'm a member of a private scheme and also a member of Nssf? So we have said that you can, or your employer can contract out of tier 2, which from Adil's presentation was the bigger chunk of your contributions. So that contribution will still continue going to your private scheme. And therefore, when you retire, you'll actually have 3 funds. You'll have one, for those of us that were in the former scheme, you'll still have the All Provident Fund savings, which will be paid to you in form of a lump sum. You'll have your tier 1, which must go to Nssf for all of us. So your tier 1 will be paid from Nssf. So Nssf will pay you 2 chunks of benefits. Provident Fund has a lump sum, and then the tier 1 contributions and savings. And then you'll approach your private pension scheme, which will pay you both your current savings in that scheme together with the tier 2 of Nssf contributions. Now, just to point out that these private pension schemes are required to all separate records for tier 2. So the administrators actually to create a separate account so that they can track tier 2 contributions into Nssf. And therefore, from your private scheme, you get both your primary contributions, which is what you've been making in that scheme, whatever employers decided for you, together with tier 2 contributions from Nssf. What is the manner of accessing tier 2 contributions from Nssf? Again, the same approach. 1/3 of it will be paid in form of a lump sum, and 2/3 will be paid in form of a pension or another arrangement that's a bit complicated for today's discussion. We call it an income drawdown arrangement. Now, I did say that you can as well choose to exit from employment through various other ways. You can withdraw from employment, you can resign, you still become entitled to your pension benefits. However, the Nssf benefits have been preserved, and therefore, unless you are at the age of 50 and above, you can't access the Nssf benefits, both tier 1 and tier 2. You can only probably access what the private scheme has saved for you. But the Nssf benefits have been preserved in that regard. So for those members, they have an option to transfer. So if you're moving, say, from one employer to another, you can actually transfer your full savings, including the Nssf savings, tier 2, to another contracted out pension arrangement if you're moving on to an employer who has another pension arrangement. Or you can as well transfer it to an individual pension arrangement, provided that scheme has actually contracted out from Nssf. So that would be the arrangement. As I said, the key difference is that you can expect to receive part of your benefits from Nssf in form of a monthly income, which is a key deviation from what we used to have in the previous arrangement. Thank you very much, Madam CEO.
Thank you. Thank you very much, John, for that clarification. I think that was one of the main questions that employers have. Let me now hand over to Grace Kaume, who is our human resource and administration manager here at the Federation, to take us through the question and answer session. I know you've been posting your questions there. We've been tracking. I think someone's been answering them. But Grace, perhaps you can allow the panelists also to respond.
Great. Thank you very much, Edie, and thanks, panelists. So there are quite a number of questions that have come through. I try to bundle them as much as possible and see those that we can address in this particular section. So I'll start with the basic ones because we've received quite a number of questions, this particular one, on the issue of, are we applying these on the basic pay, on the gross pay, and there's another word that has come through that the regulations talk about fluctuating emoluments. So this particular question is addressed to Sandeep. If you can provide clarity on what this 6% is being applied on. And when you're answering that, I would like you to address the question of what happens to the casuals, people who have casuals who are working with them for 5, 10 days or 12 days in a month. How should employers treat that? How should they treat consultants? And also, how should directors who are earning some directors' fees from different companies be treated in as far as this particular contribution is concerned? Sandeep, over to you. Sandeep, are you there?
Sorry, Grace. I was just trying to unmute. Okay, Grace.
Okay.
So let's take the first one, which is a very good one on is it basic pay, gross pay? And then what is this? How does one look at fluctuating emoluments? So Grace, if I look at the Act, the definition of pensionable earnings appears to be gross earnings, okay, which means it is your earnings, it is all earnings, but excluding fluctuating emoluments. And fluctuating emoluments would ordinarily mean things like bonuses, overtimes, commissions, and the like. So anything that is regular, such as housing, would be deemed to be part of earnings. However, when we then look at the definition of fluctuating emoluments in the regulations that were issued under the Act, we believe there is a drafting error, and that drafting error appears to suggest that for the time being, the pensionable earnings can be the basic salary, excluding things like housing allowance. Okay, so the Act is very clear that it is, to me, it is gross earnings, excluding things that are fluctuating, such as bonuses, commissions, and the like. But the regulations appear to have a drafting error, which suggests to me that for the time being, you can use basic pay. But this is subject to legal and clarification from the Nssf itself. I suspect they will need to make an amendment to the regulations in time. I hope that answers that first question. So for the time being, I think employers can probably use basic pay. To your second question, what happens with casuals? So my understanding is that for casuals, you can't have a contribution based on pensionable earnings. So the indication is that the cabinet secretary will prescribe a daily rate to be paid in respect of casuals. If you look at the previous Act, it talked about a special contribution for casuals. The new Act provides that there will be a daily rate that the cabinet secretary will issue, but they haven't issued it as yet to my knowledge. Okay, to be honest with you, I'm not quite sure on how to deal with directors. My understanding is that consultants, they would file their own returns, so they would probably be deemed to be self-employed, and they can make self-employed contributions to the new Provident Fund. I believe the mandatory contributions would not apply to them. But I think this is another area where some sort of legal clarification will be needed. Okay.
Great, thank you very much. So we come to John. John, you've indicated that the period within which employers should apply and get the exemption is, a period of 2 months, which is 60 days. So there are questions coming through and asking, in these 60 days, what should employers do? It's February now. Does it mean that they're supposed, and especially those who have more superior schemes than what Nssf is offering, should they remit Tier 1 and Tier 2 with the new rates and still continue contributing to their private schemes, which are already superior to what Nssf is offering? Should they halt one? If so, which one should they halt? Over to you, John.
Thank you. I actually expected that question. So it's a valid concern for members, because as Madam Jacqueline alluded, one of the biggest concerns for employers is the issue of cost. So when we are discussing an element that might introduce an issue of double cost for the employer, something that the employers may not want. And even us as a regulator, we have a mandate to protect the interest of employers in these pension schemes, because pension schemes are voluntary. And therefore, we have one of our key interests is actually to protect their interests. Now, going straight to the question, as I said, some employers introduced provisions in their trust deed and rules back in 2013, 2014. which allows for NSSF contributions. So if you are an employer who your trusted and rules allows you to actually net off current contributions to your private arrangement, you net off what is going to NSSF, then in that regard, we can say that you are almost covered because you can actually net off the tier 2 that you have to contribute in the first 2 months. Because the way we see it, it's like every other employer must at least make 2 months contribution of tier 2 to NSSF because of the 2 months notice period, according to the current law, unless that is revised or considered by NSSF. So in the first 2 months, you can actually net off your tier 2 contributions to NSSF from your current contributions to your private arrangement. So that will assist you to overcome the issue of double cost where you have to contribute both to NSSF and to your private scheme. However, there is a catch. There are some schemes that have not met those provisions. So if you do not have those provisions in your trusted and tools, then it becomes a bit murky for you to do the same, to operate on a similar arrangement of netting off, because it can be legally challenged that your scheme rules do not provide for such an arrangement. So your members can actually ask why you netted off if it is not provided within the scheme rules. So yes, I do agree that there are those teething issues, there are challenges that we really need to discuss ourselves and NSSF and try and see how we can overcome them. However, some of them as lawyers will tell you something that is very explicit in law, it becomes a bit difficult for you to negate the same if the law is very explicit. So the law says you can only contract out within a period of 2 months. If any FRBA was to issue you with a certificate today, you would still require to do tier 1 and tier 2 contributions to NSSF for at least the next 2 months. And yes, I said some employers for that, they're covered because they might have provisions that cover them in the trusted and tools. However, for some employers who are not covered, then it becomes a bit tricky. And therefore, unfortunately, there might be an element of double cost in terms of compliance. Thank you.
Okay, thanks, John. I'll come back to you. There are quite a number of questions again around that. Issues of, are people going to access tax relief on contributions that are being made to NSSF? Will the money that is deposited there earn any interest? And then you can tie that up to the question of these ceilings, because we've been given the ceiling, the first 5-year ceilings. What does that mean? After 5 years, are we likely to see another expansion? What informed these, graduated scale, which the comments coming through are saying that the upper limit, especially by year 5, are really high, and it looks like people will be remitting, a lot of money to NSSF and struggling to survive.
Thank you. These are very good questions. I'll try to address each of them. The first one is on the element of interest. Yes, it's affirmative that NSSF is required by law to invest member savings. That is both as per the NSSF Act and per the Retirement Benefits Act, which NSSF is required to comply with. And therefore, NSSF is mandated to invest members' savings. And these savings are actually invested by professional fund managers. So NSSF has recruited quite a number of fund managers, and these are professionals whose work is just to think about investments and the best assets where to place member savings in. So yes, your savings, rest assured, will earn interest because it's one of the principles of investment. Otherwise, it will be the logic if you invest money and it's not invested, more so in the current scenario of high inflation rates. In terms of taxation, the NSSF Act is very clear that both the NSSF contributions and the benefits from those contributions will be tax exempt. And therefore, that is in black and white. As a regulator, we expect the same to be the case, that the government has actually gone a step ahead to give members an incentive by giving them tax breaks, both in contributions and the benefits that they get from the increased contribution rates that we are seeing. In terms of the ceilings, yes, it's a big discussion. Unfortunately, it's what the law has provided for. that in the first 4 years, the numbers have actually been set of the lower earnings limit from 6,000 to 9,000. But after that, it's actually open-ended. So they move in line with how our wages or salaries grow over the years. So both the lower earnings limit and the upper earnings limit will continue to reflect the current economic scenario and the salaries that we are earning. So it's a valid concern that these contribution rates will keep on increasing to Nssf, and they will keep on increasing in accordance with the growth in our salaries in these countries, both the minimum salaries and the average salaries. That one, unless we are to have engagements with government and Nssf and to see and try whether that can be amended. Unfortunately, at the moment, it remains to be the same. However, as an actuary, having practiced in this industry for quite some time, I would say that having contribution rates that reflect your salaries, it's actually a good thing because there is inflation. If you contribute a constant amount, like we have been doing, 200 shillings, over time it will be overtaken by the inflation effect. And therefore the value of your savings will actually be eroded. So it's actually a good thing to have your salaries or your contributions to a scheme, whether a private scheme or Nssf, reflect either your salary or the salaries in the economy, because they actually grow in line with inflation in the country. Thank you.
Thanks, John. So back to Sandeep. As we almost get towards the end of this Q&A session, there are questions around voluntary contributions and whether those are allowed within the new act, the Nssf Act of number 45 of 2013. How is that to be treated? What happens to employees who are on probation and employers currently do effect pension contributions upon confirmation? How should they treat that for such employees? And then who applies, who makes an application for employees who have private schemes, which are probably not necessarily sponsored by the employer? Sandeep, over to you.
Thanks, Grace. I'll respond to those, but before I do those, I just want to pick up on a couple of things that John mentioned, which I think are important. That first and foremost, Grace, that as John is saying, yes, as the earnings limit is adjusted upwards, the level of contributions will go up. And effectively, most Kenyans should know that in the next 4 years, the effective contribution rate for everybody will become 12% of salary. Okay, so there is a graduation, there is a transition, but the eventual aim is that for those contributions to get to the 12% for almost everybody. Okay, and I think Adil can explain that as the limit goes up, effectively everybody's earnings will be below that upper earnings limit. So the effective contribution will be 6 and 6, which is a total of 12. Okay, and I think it's important for employers to plan on that basis. Okay, so let me just take the next questions. And so when it comes to voluntary contributions, yes, the Act has a provision for there to be voluntary contributions over and above the statutory contributions, and those would go to the new Provident Fund and can be taken in cash, and they will also earn interest. So there is a provision for voluntary contributions, whether it is through the Nssf or through your own private pension scheme, if you have opted out. Okay, a good question around probation. So the retirement benefits regulations require that if somebody joins an employer, they must be admitted to a pension scheme within 12 months of joining. So the waiting period to join a scheme cannot be more than 1 year. Now, when I look at the Nssf Act, it is silent. It appears to suggest that those contributions kick in immediately. Now, we feel that, look, this is one area where clarification is needed, because there's no point in admitting somebody who, if they are not confirmed, you will just have made contributions for 3 to 4 months or whatever it is. So this is an area that clarification will be needed from the Nssf as well as the RBA. The next question is, when it comes to private schemes that are not associated with a sponsor, such as umbrella funds, who makes the application? It would be the sponsor of that private scheme, whether it's an umbrella scheme or a personal pension plan, that would make the application for contracting out to the RBA. Okay, I hope that answers those specific questions. But Grace, whilst I've got the mic, I just wanted to ask, there's a huge amount of concern around the immediate implementation of the Act. And everywhere we go, the biggest question is, this is happening in the middle of our financial years, in the middle of our budgets, adjusting payrolls, everything, all these things take time. To what extent, would the FKE write to the Nssf or the policymakers to request an extension? Because if you remember in 2013, when the Act came in, it was assented to in December 2013. It was supposed to come into force on the 14th of January 2014, but actually the implementation of the contributions was delayed to May 2014 to give employers time to be able to put their payrolls, to be able to do the opting out if they wanted to. And this time around, it appears that that time is not being given, right? And that is why there's an element of surprise, that this has been sprung on employers, okay? So I'm not sure, Jacqueline, I believe you're still there. Is there a way that, you could still write? We have done so. Would it help if others did the same?
I am still here. I will address it when I'm concluding, Sandeep.
Okay.
Thank you for that very important question. And it's really one of the questions coming through. Yeah.
Great, thank you. I think we'll take one final round, and this time we'll go back to John. There are questions coming through then on penalties. What happens for employers who are not able to comply immediately or over a period of time? Is RBA giving a grace period, even though they have indicated the effective date is indicated? And if so, what are the penalties? What are the employers supposed to be aware of as they start off in terms of costs should they not comply?
Thank you. That's another pertinent question. Now, and I just want to clarify that yes, there are penalties that have been provided for in the law, and these penalties are not from the regulator. These penalties are payable to the provider, who is Nssf. And Nssf is one of the schemes that we supervise and license. So the penalties, just to be clear, are not payable to the regulator. Ourselves, we do not have a timeline for employers to apply for contracting out because we said it's voluntary. As an employer does not have to contract out of Nssf. They can choose to make Nssf contributions and at the same time continue to manage their private scheme. So as a regulator, we do not have timelines for employers to apply for contracting out. We are leaving that to the employers to decide when they will be ready to apply for contracting out. And therefore, in that regard, we do not have any penalties for the same. I think the worst we can do is to declare an employer who has applied a contracting out certificate, and there would be reasons why I would choose to do that. So the penalties are payable to Nssf, and I just want to confirm, yes, there are penalties if you do not comply, I believe, of 5% of the contributions that you should have remitted to the scheme. And therefore, the law expects full compliance. And therefore, I'll just go back to what Sandeep requested, that if they can be engagements to extend the period of compliance so that it gives the employers a grace period to be able to comply. I think that would be the best approach at this moment. Because as I said, a lawyer will tell you if you have something that has been provided for in law, then it becomes a bit tricky for you to negate it. So as it stands, there are penalties for not complying with the Nssf contribution rates. The best way we can do with that probably would be to have engagements to extend the period of compliance. Thank you.
Great, thank you. And the last one for Sandeep is around employers who have private schemes, either with umbrella schemes or their own, but the contribution rates are below the 6%. Does it mean that those schemes then become redundant immediately, or what happens?
Grace, back to me? Yeah, okay, sorry, Grace, yeah. So yes, if the contribution rates are below the levels that are needed to meet the reference scheme test, then yes, those schemes would not be able to contract out, and therefore they would. You can still continue with them, not a problem, but then the tier 2 contributions have to go to Nssf. So
Okay,
you have
thank you.
a scheme to get it to the minimum contributions required under the Nssf Act.
Okay, thank you very much. So we have quite a number of other questions. We may not be able to address all of them in this session. We'll try and put them together and share with our members and those who attended this session. So at this point, I would like to see if there's any other critical one before we get to a point where we do the wrap up. Yeah, so at this point, I'd like to hand over back to my CEO so that we look at the discussions that came through. Most of the others, I think we cover in the documentation that will be issued out from FKA.
Thank you very much, Grace, for taking us through that process very well. This has been a very interactive session, albeit virtually for most people, around the implementation of this Nssf Act 2013. Indeed, part of the challenges we have is the speed with which the changes have come. And that has put us in a bit of a spin, to be honest, as employers. And as members have kept on asking, and really in conversations with different stakeholders, it's clear that the lead time that Nssf has given the immediate implementation of the demand for immediate implementation has some real challenges for employers. When the court issued its decision, we did try to engage, and I know there was that discussion about the lead time. This is something employers have asked for a very long time, that when a change happens, could we be given time to adjust? And you see, now, even having listened to both Sandeep and John, you can tell that much as everybody would want to do the right thing, there are practical challenges. So we will continue engaging Nssf when the memo or the notice came requiring immediate implementation. To be honest, we were surprised. But I think there's a lot of pressure about implementing this so that we can start saving towards pension, which is a good idea. But retirement is a long-term thing. And as you can see, you'll be accessing those pensions, at least under the new law, only when you're 50. So I will undertake on behalf of FKA to continue engaging. This matter, I think, has taken a life of its own. It's very much in the public domain, but it is important to carry everybody along when this kind of change happens. The contributions you have made have highlighted the need, I think, for clarity on a number of areas, the need for further engagement on making this contracting out possible, because the RBA is stuck with a 2-month time lapse, which they have to honor, and employers are stuck with the 9th of March deadline. So somehow we have to find a way forward that works as a country for us to be able to comply. It is not feasible for employers to pay twice for the same benefit. And we frequently find ourselves in these kinds of challenges. So we hope that there'll be some meeting of minds on this particular issue so that we make it possible for businesses not to have to pay twice. You have indicated, John, I think in terms of summary, that we don't actually have to opt out as employers, but then you have to then decide what to do with the scheme that you have, whether you have a provident fund or a pension scheme. A lot of employers have them. I think the numbers that Sandeep shared, that were about 2 million Kenyans, it's only the Nssf that we have, is also a pointer to the fact that Nssf, because of this increase in contributions, will also see quite a significant increase in the amount of money that they're getting. But as a country, I think dialogue is important so that we manage the change well. As employers, we've also had I think the warning, the pointer, the advice from Sandeep that we shouldn't focus on year one, focus on 5 years from now, significant increase that we will have in the level of pension contributions that we make. This would be a good thing for those who would be retiring on a decent pension. But I think as employers, the advice there is to plan for it, because it will be quite a significant amount of money if matters stay as they are. So that is what I want to say for now. I want to give my two panelists a chance to give some very brief 1 minute or 30-second parting shot, one key message you want to give the audience before we wrap up. So let me start with John. Your parting shot.
Once again, thank you. Thank you, Madam CEO. I would wish by once again thanking the FKA for inviting us to engage with your membership in this forum. We are delighted to have participated. We also want to appreciate the attendees who have attended in big numbers. It is our hope as your panelists that you a few hints here and there that can assist you. As a regulator, I want to point out that we do welcome the changes. We have actually been for the Act, and we have been for this Act just for two primary reasons. The first one is that the Act is for sure going to deliver more superior retirement benefits to members. And as a regulator, we have a key interest in promoting government policy in assuring that members that exit from employment have a source of livelihood in their retirement. So the fact that it's actually increasing those benefits as a regulator, it's something that we do welcome. Secondly, it is playing a critical role in our economy. We are increasing savings, and therefore our cost of borrowing is likely to come down, which would mean that we can make investments and our factories and industries can actually grow, which is actually a boost to our economy. And let's remember that these savings actually invested in the same economy. So a growing economy, it's actually a good thing for our savings. But we are, as a regulator, very much alive to the fact that all this needs to be done within a framework where it's a win-win for everyone. Employers have a cost to meet. Members are looking at the benefit, but they also have a cost to meet. So we are trying to look at a win-win scenario where no one feels oppressed by the other party. Then finally, we do give our commitment as a pensions regulator that we are going to give our support to the employers and the industry at large so that they can comply with the provisions of the law. Thank you very much and have a wonderful evening.
Thank you very much, John, for that parting shot. Sandeep, over to you in 1 minute, your parting shot.
Yes, Jacqueline, I will stick to the 1 minute. And as I said earlier, yes, of course, a piece of legislation of this type evokes a lot of emotion, concern, and even annoyance when you look at when you look at social media. People see this as a draconian piece of legislation, yet another tax on already overtaxed Kenyans, and coming at completely the wrong time, at a time when the economy is not doing well. But I feel that if we appreciate that, look, the purpose of this act is very noble. The purpose of this act is to improve the future financial well-being of Kenyans. It is to fortify our citizens against the economic shocks that they continuously face in their lives. It is about bringing many long-term benefits to our economy, such as the savings that John Woolley talked about, so that we have our own pool of savings that we have mobilized that can be channeled into productive areas of investment and help to fuel economic growth, create the jobs that we so desperately need. Those savings will help to reduce the cost of borrowing in our country. So yes, there is a lot of short-term pain, but I believe it should be, there is a lot of long-term gain with a piece of legislation of this type. My only plea is, if there were just a little bit of a grace period that could be given to employers so they don't feel this sense of panic and are able to plan over the next 2-3 months and comply, which I believe everybody wants to do. So thank you, Jacqueline, again for inviting us and giving us a chance. To those employers on the call on this webinar who want advice around design, administration, very, very happy to help you as well. Thank you.
Thank you very much, Sandeep. Very valid views. We as employers, as I started by saying, support the idea of employees having decent pension. It's unfortunate that the implementation of the Nssf Act 2013 keeps running into headwinds because of the rush with which we implement change in this country. It is our appeal that time be given for employers to prepare for the change, because pension is a long-term arrangement. We are going to be contributing to this for a long time. So it's important that we get it right. It's also important that we take into account the overall cost to business and perhaps review the levels and give it more time, because we must also keep people in employment. Employees are struggling, and the level of contributions for some is quite significant. If you increase the 200 bob by 10 times what it is. So that's the conversation we need to have as a country. I think employers and FKA in particular has often been misunderstood on this issue. We do not object to the increase in pension, but the way of getting there is where we need to engage so that we have a win-win and we achieve the long-term plan that we have. This was important, an important conversation with you, our members, because when we talk to government, we need to carry your voice with us and to know where your pain points are. And a lot of members are logged in. There are some non-members who are not logged in. The Federation of Kenya Employers membership is open to all employers doing business in this country, whether you're small, whether you're large, whether you're an NGO, and in any sector. So I would invite you to join the membership of the Federation. All you have to do is go to our website to see that, so that when we speak on your behalf. We also have a lot of training programs to build your capacity and competence. We invite you to take part in these training programs, which help you to understand the law, starting with the Nssf Act and many others that we are running, including one that is running tomorrow on managing discipline, and also on labor laws later on in this month. I want to wrap up by also inviting you members to join and log into the Federation's portal. We have a members portal where you can just go using your company name, log in there, and you'll be able to access our services online. This is a conversation we want to keep alive. We will engage the Nssf as I've undertaken, hoping that they will give some reprieve to employers to be able to get the opt-out from the RBA within the 2 months. That is actually the period we had asked for. We had asked for 6 months. When that wasn't possible, we asked for 3 months. When that wasn't possible, we asked for 2 months. So I was like that man in the Old Testament who was praying and asking God, if there are 100 people in the city, will you spare us? If there are 50, and he went down to 10, but that didn't happen. But I think the window is not closed yet, because the 9th is still, that gives us a few days, and we'll keep you informed should that happen. I want to thank John and Sandeep very much for enriching our conversation and for sharing with us your deeper understanding of the role of RBA and also the implications of this act on employers. For those of you who logged in, there's still some 878 people logged in. Please, if we didn't specifically answer your question, we're still available, and you can engage us if you're stuck, so that we are able to clarify any aspects that we need to clarify, and also to hold other conversations such as this, should there be need. We'll keep you posted if there are any developments. I know there are court processes that are happening. Again, we'll keep you posted on the developments in that regard. For now, from us here at the Federation of Kenya Employers, asanteni sana, and let us stay engaged. For now, kwaheri.